Alex here with part 209 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my access parental rights have been terminated. Number two, the nutshell version as to the purpose of this series is to show my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We go into my motion to amend a judgment, which is the final judgment on arrearages to include the last few charges, both child support and medical. Basically, even though my ex's parental rights have been terminated and so have her parental obligations, only from the date of termination of parental rights is that the case. So all of the remaining medical arrearages and child support arrearages from before that date still accrued. And so what I'm doing here is basically tying up all of the loose ends and lumping the remaining charges into the judgment on arrearages so that those can be collected as well. I don't know what to think with the perspective of, now that you've done the TPR and adoption, just walk away. To me, it wasn't an emotional decision. And it was just a matter of fact that monies were owed. And I had worked in collections, and I understood that oftentimes monies are collected years later, and that you don't take it personal, and that you just file the paperwork and do it. If something would have happened and I would not have gotten those monies, I would have just said, okay, I couldn't get the monies. It wouldn't have been an emotional reaction for me one way or the other. In fact, walking away without collecting the last of the arrearages would have been more of an emotional reaction to me, given all the experience I'd had with the court system. So I think this is going to be really hard for some people to understand, because they're going to just be like, court is scary, and this is like, oh, the adoption and TPR were amazing, and therefore I'm just going to, leave that stuff or take that and just leave and not come back. But for me, after 8 years of litigation, court wasn't scary anymore, and my mindset was very similar to what I describe in the video, low risk, low reward, which is sometimes there's situations where the reward is low and people think, why bother? But the risk is also low, and so why not? It's one of those things where even though the chance of getting something is low, the amount of effort that you put into it's also low, so you might as well. People don't see it that way. People might see it like having to run a 10-mile marathon, or I don't know how long a marathon is, to get $5. Whereas for me, it's like having to put a letter in the mailbox to get $5. To me, it's just $5. That's true, but you just have to walk in and put a piece of paper. It's not. Things change when you go through the court system a lot. So for me, this was not an emotional decision to collect the remaining arrearages, and it did take 2 years, and that's it. I didn't gripe about it. I just filed, got the judgment on arrearages, waited and waited and waited, and 2 years later, the money came in. So my recommendation is if you're owed money, follow the process and collect it if you can, and if not, then just say, okay, well, I tried and it didn't come in. There's no reason to get bent out of shape if it doesn't happen, and scream and yell, because there's just some circumstances that are out of your control. But at the same time, I feel the same way, that there's no reason to really not, I don't know. You can post something down in the comments if you disagree. I think there's a lot of people who, especially if you know what, watch the video on the topic, low risk, low reward, because it's very counterintuitive to get people to reach my way of thinking as to why I continued on to collect the last of the monies. And what can I say? Ultimately, it was successful. And we had spent so much money on our son's braces and all this other medical stuff that came up later. It was put to good use towards him anyway. One way or the other, it helped. All that being said, let's go ahead and take a look at what I have filed. Here we have the motion to amend judgment on child support and medical arrearages. Standard introductory paragraph introducing myself to the court as a proper person litigant, meaning I don't have an attorney, and that I am moving to amend my judgment on child support arrearages. Here's a summary. We share a common minor child of age 9. We separated in 2008. My ex's parental rights have been terminated, and an existing judgment on child support arrearages and medical obligation arrearages should be merged with a judgment on new child support and medical obligation arrearages. Factual background: the court entered judgment in favor of me and against my ex for medical arrearages. The court then ordered child support abatements in my ex's favor. The court ordered my ex to pay half of the medical, dental, and vision premiums. I mailed to my ex a demand letter consistent with the law reflecting an additional $5.4 thousand in child support arrearages and $702 in medical, dental, vision premiums and $692 in medical obligations. On August 11, 2016, the 8th Judicial District Court terminated my ex's parental rights. Legal analysis: if an order issued by a court provides for the payment of support of a child, that is a judgment by operation of law. I have compiled a ledger reflecting the previous judgment, accrued child support and medical obligations, voluntary and involuntary payments made, including set-offs and interest and penalties that have accrued on the previous judgment. The previous principal balance of $2,374 should merge with the $5,483 in new child support arrearages and $702.80 in new medical, dental, vision premium arrearages and an additional $692 in new medical obligation arrearages for a total amended principal amount of $9,253. This is just going, we'll go through the exhibits, guys, and you'll see all the stuff that's being added in here. And we're talking then about accrued interest, prejudgment interest, penalties, and all that stuff that gets lumped in there. I'm acknowledging that my ex's ongoing obligations have been terminated as of August 11th, 2016, and that prospective child support will continue, and that prospective support of our child will continue through myself and my wife. I'm entitled to an award of costs under 18.160, and I have incurred $25 in filing fees for the filing of this motion. I've also incurred $11.42 for the mailing of the demand letter. The total costs incurred are $36.42. I'm entitled to interest under the law, and that's going to be at the legal rate, which is defined in NRS 99.040. I'm also entitled to penalties, which is defined under NRS 125B.095 sub 2. Hearing. Let's see here. My ex was obligated to request a hearing under the law. She has failed to do so, and I do not request a hearing on this matter. Mediation. I've said this a million times. Mediation is not appropriate in this case. If you want to learn more about why, watch my video on the topic mediation and settlement. Also, you can see there's a local rule that is a lifesaver in my opinion, and that is WDFCR 53 sub 14B3. This is how you get out of mediation in Washoe County. It's a wonderful rule. Conclusion. Let's see, what I'm asking for is an amended judgment totaling $9,253 with prejudgment interest in the amount of $1,658 with post-judgment interest and penalties at 15.25% per annum and an award of costs in the amount of $36.42. Verification, which is swearing under penalty of perjury that all of the facts alleged in this motion are true and correct. Rule 5 certificate of service indicating this document was mailed to my ex's P.O. Box. We also have the motion opposition notice indicating that I do not have to pay a filing. Wait, I do have to pay a filing fee with this motion, and that is going to be a $25 filing fee. List of exhibits. We've got the demand letter, the order terminating parental rights, the proof of restricted mail, and the ledger. Exhibit 1. This is the NRS 125B.140 letter that I sent to my ex. This letter has to be very, very specific and very consistent with the law. If you do not do this perfectly as required by law, it will not allow you to merge any kind of dollar amounts into a judgment on arrearages. So definitely watch. I know that I go into this in detail in one of the other videos where I've done this for the very first time, but for now, let's go ahead and move on. Pending child support. Here we have the ledger. These are all of the child support amounts that have been accruing. There is an attorney fee offset here on 11/13/2015 for 17/15. This is what my ex was awarded in attorney fees. You can see the little asterisk which says pending appeal. That's going to go away because this appeal is going to reverse my family court judge's erroneous decision. We've got pending medical obligations, which is just including more arrearages, more arrearages are going to be lumped in for all of these appointments, broken fingers, stuff like that. We have medical, dental, vision premiums, which is going to add in more money for the premiums. We have Exhibit 2, which is the order terminating parental rights. As my policy is with my Docket series, I don't go over documents again. So if you want to read this for yourself again, you can go down in the description below, click on the link, download it for yourself, take a look. If you see something that I should have covered, mention it down in the comments below. But if you have been watching this series in order, then you would have already seen my analysis on the order terminating parental rights. Exhibit 3, we have receipts and a certified mail restricted. You have to send it restricted because the statute says so. If you do not do this, that statute won't save you. So again, guys, this receipt and this certified mail with restricted service is all required by statute, and that's why I'm providing it to the court. Exhibit 4, we have, what is this here? It looks like more ledgers. This is not legal. If you want to look through it yourself, you see something interesting, let me know. But I don't have much to mention. It's just monies that are accruing. Next document, we have the request for submission. As my previous videos, I've gone over this enough times. If you really want to learn more about the request for submission, please take a look at the video on the topic request for submission. Here we have the Rule 5 Certificate of Service indicating this document was also mailed to my ex. Going into the aftermath, I filed 2 documents. One of them was one of them required a filing fee of $25, so I incurred $25 in filing fees. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees, and my ex did not have an attorney, so she incurred $0 in attorney fees as well. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.